On the record, in the matter of the people of the state of Michigan versus Brandon Craybill, call number 23-03160, council appearance.
Good morning, Your Honor. Assistant Attorney General Emmanuel Owusu Coker on behalf of the people.
And then I see Mr. Brandon Craybill is present via Zoom without counsel. This matter was reset for a probable cause conference because of the issue of having the bond applied. We were notified that the issue was that the bond was in a third party's name. I do see a new order here, and it's the third party Jennifer Long. Is that correct?
That is my understanding, Your Honor. I did get that information from Mr. Craybill and prepared a new order to have that bond assigned to the support case.
Okay. Mr. Craybill, can you unmute your device?
I'm sorry, what was that?
My question was, if this third party who posted the bond on your behalf, that's Jennifer Long?
Correct, it is.
Okay, and she has signed this order agreeing
Yes.
to have that applied?
Yes.
Okay. Sign the order dated for today. We'll reset this once again. Hopefully by then this will be applied and we can put this portion to rest. Was there another portion that accrued or is he still on top of that?
Oh, no, Your Honor. Once that is applied, we plan to dismiss the case, Your Honor.
Okay, so let me get you a new date.
To February 16th at 8:30.
February 16th at 8:30. Do you have any questions today, Mr. Craybill?
No, thank you.
No problem. Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
Thank you. Have a good night. Mr. Madeline, which matter are you here for?
I am here on Albert Palacio. Go find the prosecutor.
Yes, please. On the record, in the matter of the people of the state of Michigan versus Albert Palacio, file number is 23-03335, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Mike Mataloni on behalf of Mr. Palacio.
Okay, how are you, Mr. Palacio?
Thank you, ma'am.
Okay, today's the date and the time that's set for a probable cause conference. Let's see here, I do have an offer from the people. Mr. Palacio, the people are offering for you to plead guilty to an added count 2 of use of a controlled substance and under MCL 333.7404-2B. They will dismiss count 1 and the habitual offender notice. There's a sentencing agreement of fines and costs only as the killer brew. Is that your understanding of the plea offer?
Yes, Your Honor.
You want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Okay. You have the right in this matter to proceed to a trial. You have the right to jury trial. You want to give up that right in order to accept the offer?
Yes, ma'am.
Okay, so you have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to require the prosecution prove your guilt at a jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You want to waive those rights as well, correct?
Yes, ma'am.
Okay, you have the right to remain silent at your trial, not have silence be used against you. You have the right to confront all of your accusers or any witnesses the prosecution intends to call against you at your trial. You have the right to cross-examine those witnesses, and you have the right to call your own witnesses or present evidence at trial that you believe show a defense to the charges being brought against you. You recognize those rights?
Yes, Your Honor.
You signed this document?
I did, ma'am.
Do you have any questions about any of these rights?
Oh, Your Honor.
Okay. Anybody threatening you or promising you anything to get you to give up your rights today?
No, ma'am.
Okay. Are you entering a guilty plea to the added count of 2 because you believe you're guilty?
I am.
Understand that a guilty plea could, to that count could impact travel or immigration status you may be seeking.
Yes, Your Honor.
Also, a guilty plea to count 2 could be a conviction that you may need to report to your current employer. You may need to report this on a future job application.
Yes, ma'am.
Okay. As to the added count 2, use of controlled substance, how do you plead?
Guilty.
Factual basis?
Yes, Mr. Palaccio, on November 5th, 2023. Were you in the area of South King Boulevard?
Yes,
And is that in the city of Lansing,
yes,
Ingham County?
yes,
And at that time, did you have in your possession cocaine?
yes,
And were you using that cocaine?
yes.
Did you have a prescription for that cocaine?
No,
Did you have any other lawful right to possess it?
no.
Any questions from the prosecution?
No, Your Honor.
Okay. Are you currently on probation or on parole?
No, I'm not.
The court is satisfied with the factual basis. I'll accept your plea. If I get plea to be made freely, voluntarily, and intelligently. There's a killable agreement to fines and costs only. I'm not a party to that agreement. That's between you two. I'm gonna order you to go meet with probation so they can prepare me a pre-sentence report and recommendation. After reviewing that report, I'll determine how you should be best sentenced. If I decide that you're going to be a sentence outside of what your agreement was, I'll then give you the opportunity to withdraw your plea. Do you understand that?
Yes, Your Honor.
Okay. I'm gonna give you a sentencing date. When you leave here, you go downstairs 142 probation so you can check in with them. They'll get some information from you. You'll have to complete a questionnaire. And then you're also gonna have to undergo a substance abuse assessment, okay? Sentencing date's gonna be March 21st at 9 a.m. You can appear for sentencing via Zoom, okay?
Thank you.
No problem. We'll get you notice to appear. Do you have any questions today?
No, Your Honor.
Okay, any additional matters for the record today?
Nothing for the people, Your Honor.
Oh,
Okay, you're all set.
you shouldn't go down to the.
Yeah, I'll be on the slip here.
Do one more check.
The other people are in custody? All right, Mr. Feigelson, you guys in custody?
One of my guys is in custody and I don't see Mr. DeHaye there. I can't.
Well, that's. Have you been in contact with them?
Not recently.
Okay, I should have been sure.
That's what I think.
And we'll have your other guy brought up. Let's see, Ms. Donnelly, your person's in custody.
I have Calvin Willis in custody. Yes, I ready to go.
Are we running an exam?
No.
Have him brought up as well. See Mr. Silverthorne or Carter. I don't know what we're doing with that.
I don't think we are running either on green.
We're gonna have him brought up next.
Yeah, no, it's here.
Yeah.
No one's here on which matter.
That one is Michael Green.
And you're gonna do a nollie?
Yes, we are.
Okay, well, then we're not gonna bring him up. We can advise. We'll just do the nollie.
Okay. And I believe, if it, the court,
I think Mr. Biker was hoping he could squeeze Nathan Joyner in. Again, obviously.
He's in where?
Well, he's set for today, but if I don't usually going off like the order on the docket, but if you're fine jumping around.
He's next.
Oh, he. Someone
Yeah,
was running.
Nathan Joyner, I thought, okay, yeah, is Freeman's on, is Freeman here?
Yes.
Yeah.
But I told him that the court is ready.
Okay, we'll have Mr. Joyner brought up,
Thank you.
and let's see. Mr. Feigelson, I'm just gonna sign a nolly, you can advise your client what it
Yes,
means.
ma'am.
Good morning,
I'm gonna let him know in a few minutes, right?
thank you. Good morning,
How are you?
I'm good, how are you?
Yeah, thank you. Have a good one. Yes, thank you.
I will send that. That means it just sent to me. Didn't actually send it to
Yeah, it's a text.
No, he's threatening
I
to
will
lock him
find
out
the-
for these student security.
I'll find
I'll
the-
give you a grace
Pretty
period.
ones now.
No, no, you're not.
Because you said you have.
They just made it off. Yeah, he's thinking about it. I have one Friday resolution at 5 a.m. on truck 7. Is that how is it? You have an advice on rates? Yeah, they could have
It's
one
in
of
that,
mine.
black podium, yeah.
Then click the button saying share with prosecutor, share with events. We don't even do it.
So you got,
To be fair, I haven't looked. But yeah, no, that I know. I've had that for a while. I thought you did too.
Mr. Austin, you here with Hawks?
Yeah, we should fix that.
Yeah, sure, Honor.
We should fix that a little bit.
Are you, do you know if we're gonna run it, or are we still waiting to find out?
My understanding, Your Honor, people wish to run the exam.
Okay, sounds good.
relatively fast. Or Hawks.
He's thinking, my guy's thinking.
Okay, it should be. I don't think.
That's
it'll be
fine,
super
until
long.
9:30, he's got plenty of time.
Yeah,
Did everything go down? I was gonna see if I get a copy of the,
he did, yeah,
let me see if I get a copy of the down.
yeah.
Oh, I haven't signed it yet.
Yeah, no, wait, or come back later.
She has it right there, I think.
Yeah, sorry, what is the, I don't have the ends, the destruction numbers. I'm so, I usually have typed up.
No, that's okay. I've got it saved in my 426A. That's favorited in my web browser.
Alright, everything's good. Get ready. Yeah. I was just writing. File, and then the copy. Oh. Oh. Oh.
Joyner Brown. File at 9:30.
Yeah, not gonna trust it. The big room. Very small package. Straight, I don't want the straight line. I can't walk a straight line. I've had events. I can't come back and it's like, I can't do, I don't know what my eyes do. Then I switch.
Especially the one that I make up.
Yeah, just want to keep me busy.
I tried the touch your nose with your eyes closed once and it was like forehead.
Oh, yeah, no, I can know facial weird. I'm like, I mean, obviously, on a wall ground, I wouldn't, but like also.
Yeah, or in the middle, I have to see it.
Literally.
On the record of the matter of the people of the state of Michigan versus Nathan Joyner and file number 24-00106, Councilor Terrence.
Yes, morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Joyner, who is seated to my right. Thank you.
Okay, how are you, Mr. Joyner?
I'm good, ma'am.
Today was the date and the time that was set for a preliminary examination on home invasion first. How are we proceeding?
Your Honor, the people are prepared to proceed today. I also informed defense counsel that there are 2 more cases coming down the pipeline from my office involving Mr. Joyner and this victim. I just want to be on the record. That's why there was no offer at this time, because you can't exactly make an offer with new cases coming in the next few days.
So we're ready to proceed at this time?
Yes, Your Honor. I spoke with the victim about 10 minutes ago outside in the hallway. And ready, we also have Officer Rotuno here.
Okay. Any preliminary matters before we call the first witness?
Not from the people.
Nothing preliminarily. Thank you.
Okay, you can call your first witness.
Thank you, Your Honor. The people call Sincere Dunbar. Okay.
Yes.
Thank you.
Testing, is it working?
Thank you.
It's very glitchy for us. Sometimes it works, sometimes it doesn't.
Your Honor, may me and Mr. Freeman approach and actually potentially speak in chambers.
You want to approach or speak in chambers?
Chambers, I think.
Oh, okay. Okay, back on the record in the matter of the people of the state of Michigan versus Nathan Joyner. And Mr. Piper, you had a motion.
Yes, Your Honor. The people would ask to adjourn at this time. The victim in this case, Sincere Dunbar, was here. But I believe that she had somewhere she had to be at 10. I did not give her permission to leave. I tried to get this happening as quickly as possible to make this happen, and she knew that the case was being called. From speaking to Mr. Freeman was speaking to her just before she left, saw her taking a phone call. I've looked through the building. I've looked outside. I do not see her here. I would ask for an adjournment, especially given the fact that Mr. Joyner has 2 other felony cases with the same victim. One with the offense date being September 24th, the other one being January 6th, that are, in the process of being issued by my office. It was only technical problems holding them up that we didn't realize until this case actually came about. So they should be fixed within the next 48 hours.
Okay. And is there any objection under the circumstances?
Your Honor, I believe all the representations offered by Mr. Pfeiffer are true and they're accurate. I'm not disputing that. On the other hand, as an advocate on behalf of my client, he's entitled to a preliminary examination within 21 days of his arraignment. Now, I have spoken to Mr. Pfeiffer earlier this morning, and it has come to my attention, it's my understanding, that his office has already, I guess you call it file reviewed, or there are additional felony complaints that will be forthcoming in a matter of days, I think. And in that light, it makes sense, just in terms of judicial economy, et cetera, that the 3 of them be addressed at once, particularly in light of the fact that if it's the same complaining witness on all 3. In exchange for the prosecutor's motion to adjourn, I would respectfully move the court to adjust my client's bond down to 10,000, 10%, if that would please the court.
Okay, let's first address the issue of the request to adjourn. We did have witness or the complaining victim here today. For whatever reason, that victim is not here, had somewhere to go. And then we have the issue of 2 additional cases, same complaining witness in the pipeline. Even if I were to entertain a motion from your counsel today to dismiss this case, because you do have the right to have an exam within 21 days, unless you waive that timeline or the court finds good cause. If I were to grant a dismissal because the victim is not here right now, they're only going to reissue the charge, which means you're going to have to be rearranged all over again. And so that's not in the interest of judicial economy. So I will grant the adjournment. I'm going to find good cause to go beyond the 21 days. And this matter will be reset. I'll set it for a probable cause conference, primarily to make sure that the other 2 cases have been arraigned and they can all be set for an exam at the same time. Do March 1st. Okay. March 1st at 8:30. Okay, and before I address your bond motion, I have people of the state of Michigan versus Nathan Joyner Jr., file number 23-03180. This is a matter, Mr. Joyner, that it states here that you failed to appear for arraignment back on November 2nd, 2023. Looks like you were then arraigned on You were then arraigned by Judge Buchanan, it looks like. But however, your matter was set for pretrial January 23rd at 10 a.m. No, it looks like they reset your arraignment. That's what happened. Magistrate Milmore reset your arraignment to January 9th, and you did not appear for that. Were you in custody on January 9th?
January 9th, no, Your Honor, but that case was dismissed. It was for driving unsuspended, and the case was dismissed originally. I just spoke with vendor attorney. And she stated that she would put on record that it was not my fault that I didn't get the notice to appear again because under my understanding, the case was completely dismissed. So I didn't know I had to appear, but I do appear to court dates.
Okay, well, this is the issue that it was reissued, obviously.
I did not receive any notification. I don't know why.
What's your address?
My address is 900 Long Boulevard, Unit 286.
That's where your notice was sent. Nonetheless, the matter is going to be reset for a pretrial. I'm going to arraign you today. So again, you already know what the charges are, it looks like. I have here a misdemeanor warrant and complaint that alleges that on or about March 11, 2023, that you did allegedly drive a motor vehicle at or near the vicinity of South Waverly Road and West Jolly Road, City of Lansing, Ingham County, State of Michigan, while being a person whose operator's license has been suspended contrary to the provisions of the Michigan Vehicle Code being 257.9041. That's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. There's a count 2 alleging that you did then and there operate a vehicle on a highway or other place open to the general public, including any area designated for parking of vehicles at or near South Waverly Road and West Jolly Road. Alcohol content of 0.08 grams or more per 100 milliliters of blood per 2/10 liters of breath or 67 milliliters of urine. Unlawful blood alcohol content being that of 0.11. Now, this was contrary to the provisions of the Lansing City Ordinance 402.02 and the Michigan Vehicle Code, that being 257.6251B. That's a misdemeanor with the maximum penalty of 93 days in jail and or $500 in fines. You understand both those charges and the maximum penalty?
Yes, ma'am.
You have the right to be represented by counsel. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You do have public defense counsel representing you in another matter. I assume you want that in this case as well, correct? Oh, no, here you're requesting court-appointed counsel. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute or plead not guilty, this matter will proceed to a jury trial. And you have the right to jury trial. You have the right to the presumption of innocence, so you're innocent until proven guilty. You understand that? Sorry?
Yes, ma'am.
You have the right to require the city to prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to confront your accusers and cross-examine them in court at the time of your trial. You have the right to have witnesses subpoenaed on your behalf or present evidence at your trial that you believe show a defense of the charges being brought against you. Do you have any questions about those rights?
No, ma'am.
The court will enter a plea of not guilty on your behalf. Again, this matter will be set for a pretrial. For Judge Buchanan, February 13th, 2024 at 10 o'clock in the morning, okay?
Yes, ma'am.
Set bond at $500 personal recognizance while out on bond. You need to report to all of your court dates. Now, to use, purchase, or possess any alcohol or drugs unless you have a valid prescription. You're not to possess a firearm or any other dangerous weapon. Do you have any questions?
No, ma'am.
And you're not to travel outside the state without prior approval of the court. You're not to engage in any assaultive or threatening behavior. Okay, and you said your address has not changed. I just confirmed that address, which should be the address on Long Boulevard.
Yes, ma'am.
Okay, people of the state of, I'm sorry, this is people of the city of Lansing, I believe. People of the city of Lansing versus Nathan Joyner Jr., file number 23-00191. This matter was set for show cause back in August because you owed $90 and you haven't made payment on it. This is for a driving while license, a suspended ticket that you had before Judge Ward. Didn't appear for show cause, and so a bench warrant was issued. Did you forget?
I was laid off in October, and I was doing bricklayer. I just completed bricklayer class. I'm a bricklayer apprentice, and I wasn't getting paid for it. I was struggling on paying rent with unemployment and child support, and I didn't get no reminder to pay it. I apologize.
You didn't get no reminder from who?
From the court,
We
or
don't send reminders for you to take care of your business and pay your bills.
I apologize for not paying it, but I know about it now. I will get it paid as soon as possible.
Okay, well, you knew about it before then, before you were before Judge Ward, it looks like in May. She gave you until June 30th to make the payment. Then it looks like no payment was made, set it for a show cause August 30th, you failed to appear. They reset it again for a show cause.
They reset it for a show cause.
Yeah, it looks like for September 5th, but you didn't appear. And so a warrant was issued. You need to pay $90. I'll note here that you're currently in custody. And were you employed before you went into custody?
Oh, I'm collecting unemployment right now. I am employed though, but I'm just laid off because of weather.
When can you make payment on this?
On release, I can make it the same day.
Okay, and then I'll note that here in the file. And then back on the matter of the home invasion, for your bond in that matter, looks like it was set at 100,000 cash surety with GPS tether and victim notification if possible. Counsel, did you want to address the motion?
Yep. In the last 5 minutes, I discovered the defendant's been sending video visits, e-messages, and phone calls to the victim, including from this building at 8 a.m. this morning. I have his face and her face, and 205 calls from the jail.
Motion to amend bond is denied. I'm gonna also restrict your phone privileges.
Thank you, Your
You can
Honor.
only talk to your attorney. The allegations made by the prosecutor of the contact with the alleged victim would be in violation of your bond conditions, which at the time you were arraigned, you were advised that you're not to have contact directly or indirectly with a Sincere Dunbar and or Alicia Roncal. That means you could not cause any third party to even have contact on your behalf. And the allegations that you violated those bond conditions. And so that would be a PA 53 violation. You have the right to have a contested hearing on those violations. You have the right to be represented by an attorney at that hearing. If you are found to have violated your bond conditions, your bond can be revoked entirely pending this disposition on this charge of home invasion first. Do you understand that?
Yes, Your Honor.
You also could be found or sentenced as a contempt of court order, and that's a maximum penalty of 93 days in jail and or $7,500 in fines. Do you understand that?
Yes, ma'am.
Okay, for the purposes of the PA 53, how does he want to plead?
Not guilty, Your Honor.
Okay, we'll set that for a hearing. You want to turn PCC? Yes, please. So much for March 1st at 8:30 will be the hearing for the PA 53. Again, I'm gonna revoke your phone, video, and messaging privileges while in the custody of Ingham County Jail. You'll only be allowed to have contact with your attorney. Do you understand that? Address that at the time of the PA 53 hearing. This is for your own protection because these allegations are serious and they can lead to additional charges, including witness tampering charges. I don't think you want that. I don't think you want anything that could cause you to have to serve 93 days in jail outside of what you already have pending here. Or I don't know if you have an extra $7,500 to pay for a contempt of court order when you didn't even pay the $90 on the other one. So for your own protection, I'm going to go ahead and place those restrictions until the time of your hearing, okay?
Yes, ma'am.
Outside of that, I was going to deny the bond motion anyways. I just want to put that on the record so that we don't rebring that bond motion. And that's because the information before the court indicates that there is a history of this pattern of behavior, allegedly, some stalking behavior, that this is a crime that alleged to have involved the use of firearms, and that the defendant has a history of violent behavior directed towards a victim. I think the bond set at 100,000 cash surety is more than reasonable. A bond could have been denied entirely under the NCR 6.106B1. So bond will continue as set with those restrictions while you're in the custody of the jail. Any additional matters for today's record?
Not from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Thank you.
Get copies and send them your way.
Who's on the jail on the Polycom? What's your name, sir? Can you hear me in the Polycom? Can you hear me?
Yes, yes. My name's.
What is your name?
Amos, D-A-M-A-S, last name Bell, B-E-L-L.
Supposed to be Judge Buchanan. You're supposed to be in Judge Buchanan's courtroom. They logged you into Judge Simmons, okay?
Okay,
Let the deputy know they put you in the wrong courtroom.
okay, I sure will. So I get on the button now.
Let's see. You ready to go with yours?
Yes.
Okay.
Alexander Priest, first, please.
Okay, on the record in the matter of the people of the state of Michigan versus Alexander Priest, file number 23-03532, counsel appearance.
Assistant Prosecutor Pete Petrowski on behalf of the people.
Good morning, Your Honor. Bill Weesey appearing on behalf of Mr. Priest, who's present in the courtroom and standing to my right.
How are you, Mr. Priest?
I'm doing good. How are you, Your Honor?
I'm doing well, thank you. Okay, today was the date and time set for a preliminary examination. I have a plea offer here. It says the people are offering for you to plead guilty to an added count 4 of aggravated domestic violence. The people will dismiss remaining charges. There's a Killebrew agreement. That's an agreement about how you're going to be sentenced. And there's an agreement for no upfront jail. Is that your complete and accurate understanding of the offer?
Yes, Your Honor.
You want to accept that offer?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. I have an advice of rights and plea information sheet. It's dated for today. Whose signature is this?
That's my signature.
Did you read this document?
Yes, Your Honor.
You understand the rights listed here?
Yes.
And you're willing to give up all of these rights today in order to plead guilty to the charge of aggravated domestic violence?
Yes, Your Honor.
Anybody threatening you to get you to give up those rights? Any promises being made to you if you give up those rights? You understand though that you do have the right to the presumption of innocence, so you're innocent until proven guilty. You recognize that?
Yes, Your Honor.
You have the right to require the prosecutor prove your guilt, and they do that at jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial, not have silence be used against you. You have the right to confront your accusers in court and cross-examine any witnesses that the prosecution intends to call. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charge being brought against you. You recognize that?
Yes, Your Honor.
And those are all the rights you want to give up, correct?
Yes, Your Honor.
Are you currently on probation or on parole?
I'm currently on probation. Sorry.
You're on bond?
Yes.
Okay, out of what court?
This file.
Oh, this one.
Yeah.
No other files pending?
No, ma'am.
No other probations or no probations in any other courts?
No, Your Honor.
Okay. You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Yes, Your Honor.
And also this conviction, if sustained, could have impact on travel or immigration status you may be seeking. So you may want to go up to Niagara Falls, the good side, which is in Canada, and you might not be able to get there because of this conviction. You understand that?
Yes, Your Honor.
Okay, and with those understandings, you still want to give up your rights.
Yes, Your Honor.
As to the added count 4 of aggravated domestic violence, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Factual basis.
I'd be happy to assist you. Mr. Priest, is it true that on or about November the 20th of 2023, you were at the location of 3111 West Jolly Road in the city of Lansing, County of England?
Yes.
And at that address, at that location, you resided with the victim in this case, Shonda Stevenson,
Yes.
and you and Ms. Stevenson at that time were involved in a dating relationship.
Yes.
On that date, at that location, and with that person, you got into a verbal disagreement and an altercation,
Yes.
and it started over lasagna for dinner, as I recall.
Yes.
And it went downhill very, very quickly, and things escalated. Is that fair to say?
Yes.
And at some point in time, you obtained possession of a handgun.
Yes.
At some point in time, Ms. Stevenson obtained possession of a knife.
Yes.
You understand, for the purpose of this plea today, there's no claim of self-defense. There's not going to be any questions to who grabbed what item first.
Yes.
Okay. And when the police ultimately arrived on that date at that location, they saw you and Ms. Stevenson in an active physical altercation.
Yes.
Okay. And for the purpose of this plea, you take no exception and do not dispute the fact that at some point in time during this incident, that's the final, and it wasn't necessary for you to do so. And reasonable for Ms. Stevenson to believe that she was in fear or apprehensive because of that possession of that handgun.
Yes.
Okay, and at that point in time, that would not have been self-defense.
Yes.
Okay. Now, if I missed it, this is a 769.48 plea. Did you? That thought it was on the plea sheet.
It's not on my
Oh,
plea sheet.
shit. My apologies. I'm so sorry. I can,
No objection to 769.
no objection to 694.
I'll note that there.
Thank you.
Okay. Any additional items?
Nothing from the people.
Okay. The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing. Sentencing is going to be March 21st at 9 a.m. When you leave here, you're going to go down 1 floor to the 5th floor to meet with probation. They're going to have you complete some paperwork in preparation for your sentencing, and they'll also give me a indication as to whether or not you're even eligible for 769.4A, okay? And then you can appear for sentencing via Zoom, okay? Do you have any questions at this time?
It's my understanding that the no contact conditions would obviously continue.
That's correct.
Pending sentencing. The victim resides in a home that is either owned or my client is responsible for that home. She's been unable to make financial obligations on that. It may, he doesn't want to violate the no contact, but he may have to send her legal proceedings in terms of the eviction, settling that property issue. Should we just go through counsel or?
So he's renting or you own?
It's my rental property. She lives there. It's not that I want to evict her or anything like that.
You said it's your rental property, meaning you're renting it, or you own the property?
My company owns that property.
Okay, so you own it, so you want, you may potentially have to legally evict her, is what you're saying.
There's a potential also, or just send her a rent agreement. There is a lease in place. I just want to proceed and take care of that without breaking my bond.
Okay,
As of
got it.
now,
You have, are you the only person that works at your company?
Yeah.
Okay, because you obviously have the right to proceed legally against her, and I think sending legal paperwork is not going to be a violation. At least I wouldn't construe it as a violation of your no contact order. So I'll note here that to the extent that you are communicating via paperwork for the purposes of formalizing the rental tenant agreement, that won't be construed as a violation. That could open up some doors though, and that it might be in your best interest to navigate that with an attorney.
I didn't know this was coming up. I would be happy if it pleases the court and the prosecuting attorney to have any documentation that my client wants to send to her to go through my office. As an officer of the court, I'll vet it. I'll make sure it's just about the property, and I will send it from my letterhead with my end.
Wonderful. So that'll help you there, okay? Okay, any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, have a great day.
Same to you. We're gonna get you downstairs to the 5th floor in just a moment. You can have a seat there.
Thank you, staff, for the accommodation, Your Honor. I would point out, I did check the weather. We're not anticipating any snow for quite some time.
Thank you. We have to bring him, Mr. Remington, we need to bring him downstairs to probation, and then Ms. Donnelly had somebody.
Calvin Willis is downstairs.
Calvin Willis, are we running Calvin Willis? Okay, let's bring Calvin Willis up. I haven't seen Mr. Silverthorne. Is someone covering for him?
I also haven't seen him, but no one said that someone's covering for him to me.
Yeah, he has a 9 a.m. assault murder.
Carter.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10 counts.
Oh, yes, okay.
Can someone reach out and find out where Mr. Silverthorne is? I thought I saw Miss Swanky hiding behind the computer. Miss Swanky, are you ready on yours?
I am, Your Honor.
On the record of the matter, the people of the state of Michigan versus Dustin Coleman, file number 23-03542, council appearance.
Assistant Prosecutor Paige Kraska on behalf of the people.
I don't need one from Mr. Coleman.
How are you, Mr. Coleman?
Good.
Today was the date that was set for a preliminary examination. I have count 1. Assault with intent to do great bodily harm, and then count 2 of domestic violence, second offense notice. How are we proceeding?
Thank you, Your Honor. It's my understanding that defendant will be unconditionally waiving his right to a preliminary examination, and people would do the same. We ask that the matter be gone over to the circuit court as charged.
Ms. Wanji.
That's good, Your Honor. Yeah.
Okay, So, Mr. Coleman, you understand your right to have a preliminary examination in a district court? Ms. Petrowski? You have the right to require the prosecution to put forth sufficient evidence at the preliminary examination to establish if they have probable cause sufficient that a crime was committed and then that you committed the crime. You understand that?
Yes.
You wish to unconditionally waive your right to a preliminary examination? Okay, I understand your lawyer gave you advice. That advice is for you to consider, but then make your own independent determination. So you still have to make determination if you want to accept that advice, or if you do not. If you tell Ms. Wanji, no, I recognize, I respect your opinion, but I want to run it, guess what she's gonna do? She's gonna run your exam.
Right.
So what do you want to do? Do you want the exam or no?
I don't know, I mean.
And if you need more time, I can give you more time to think about it.
I mean, I don't know, like I was never explaining what the exam is about.
The exam is about these charges, so they're felonies, and so in order to proceed with a felony charge against you, you have the statutory right to require the prosecutor put forth evidence to see if they even have probable cause to charge you with these felonies. That's your right, and you can take more time to talk to your attorney about those rights, because they're big rights. You don't need to give them up, no matter how big or how small. And I'm sure your attorney has reasons why she would have advised you the way she did, but that's up to you to decide if you want to give up the right. She can't give up the right for you. She can't force or threaten you to give up the right. You understand that?
Yes.
So what I'm going to do is I'm going to take that file back, and then I'm going to go off the record, and you're going to go talk further. And then Ms. Wanji, if he needs to sleep on it, I can reset it. Okay?
That's fine.
Thank you. Yeah.
I'm here with Mr. Hawks, Your Honor, but I was going to give an update on Mr. Silverthorne.
Oh, okay.
I sent Mr. Silverthorne a message. The matter does not appear on his schedule. It looks like he may be currently in circuit court for sentencing, but I have sent him a couple of messages.
Okay.
That's likely why he wasn't here for whatever reason. It didn't appear on his schedule, but I have reached out to him.
Yeah,
Waiting a response.
This client is in custody. This is a matter that says the witness needs a Spanish interpreter. Do we even have a Spanish interpreter?
I was able to speak with Carlos, one of the security guards, and so he would be acting as an interpreter.
I'm sorry, no, security officers don't get to be interpreters.
Okay, he had said that he had done it before. I fully admit.
For a witness in a court proceeding?
That was what he had said. I'll be completely honest. I got mixed up on who needed to schedule the interpreter. It was my fault. I was supposed to. So there wasn't an interpreter scheduled.
No worries. There's a lot of mix-ups here. We don't even have Mr. Silverthorne here. So
I mean, I know that makes it a little better, but I just want to put it out there. Like this.
I don't. We can't just start pulling security officers or probation officers to interpret, because that could open it up for appeal. If it's a witness, it's your office's responsibility to secure an interpreter. Mr. Silverthorne obviously did not have the date in either. So what we'll do is we'll go ahead and reset that. Mr. Silverthorne's going to want to be in communication with his client, so his client understands why he was not brought up today.
Yeah, and I can.
March 14th and March 14th at 9 a.m.
Okay. I'm sorry, was that 14th?
March 14th at 9 a.m.
Thank you.
We have victims here?
One of them.
Okay, we should let them know that they're free to go.
Yeah.
Okay. And then we're running Hawks.
It's my understanding, Your Honor, that people wish to run.
Yes, Your Honor, and my witnesses are on.
Okay, we can have them set up because I think Donnelly's not running hers, so I'll just handle hers and then we'll start Hawks. Mr. Coleman is talking to his attorney. Dave Roberts is a bench warrant. Fox is next. Moving along swimmingly today. You can be seated. Okay, people of the state of Michigan versus Dustin Coleman, file number 23-034542. Dustin Coleman. No. Okay, Ms. Wanji, you did speak further with your, you can just step right there. You did speak further with your client. How does he want to proceed?
We would like to have an adjournment so that he can sleep on it.
Okay. Okay, so let's see here. We already waited 21 days. I'll reset this for a new probable cause conference. February 9th.
Just a preliminary.
You need a preliminary exam? Oh, okay. March 14th at 9:30. March 14th at 9:30. No problem. Do you have any questions for the court today, sir?
No, Your Honor.
Any additional matters for the record today?
Nothing for the people, Your Honor.
You're all set, sir.
Thank you.
We'll get you a notice to appear.
Just hang out for a second.
Thank you.
Hang out the whole way. Okay.
Okay, on the record in the matter of the people of the state of Michigan versus Calvin Willis, file number 18-048881FT. Counsel appearance.
Prosecutor Paige Petrowski on behalf of the people.
An assistant public defender, Sarah Donnelly, on behalf of Lieutenant Calvin Willis, who is appearing and standing to my right.
Oh. How are you, Mr. Willis? You're a little nervous? Okay. That's reasonable under the circumstances. Let's see here. It was the date that was set for preliminary examination. Do we have necessary witnesses here?
This morning, Officer Nicholas Zuber reached out to me. He was called in for work. He's currently working on some sort of investigation for the AG's office. So I would be asking for a good cause adjournment.
Your Honor, this obviously is the date and time set for Mr. Willis's right to have a preliminary exam within 21 days. He's been in custody ever since then. Mainly because we did get a PR bond last week, but he doesn't have money or the proof to get the tether because he doesn't no longer lives in Michigan. He lives in Tennessee now. He works there. So we'd be asking for dismissal without prejudice.
First thing that struck out to me when I pulled this file is the age of the case. It's from 2018. If something took this long to get before the court, the officer should have made it his business to be here. I'll grant the motion to dismiss without prejudice. The people do have the right to reissue the charge against you. If they do, then you would have to turn yourself in and be rearranged. You understand that? Do you have any questions? How can you say that so we can hear it on the record?
No.
Thank you. We'll get you a copy of the dismissal in just a moment, okay? And you have witnesses on Hawk. Are we ready on Hawk?
Yes.
Oh. Are we running Brown?
I still have to go downstairs to talk to Mr. Brown. He's getting arraigned on something else today. Another felony file. So
I
don't-
have it.
Oh, you have it? Are you gonna arraign him, Your Honor? Oh, okay, great. So let me bring him up. Okay. So I'm not sure I'm Brown.
Okay, sounds good. We're gonna run Hawk.
Oh, Your Honor, do you believe we're running Reed?
Okay, Reed is gonna run. Hawk. Let's see if I can do. Or in the building,
Yeah, he was. I think he's out in the hallway. Your Honor.
and then,
Oh, yeah.
Brown. No, we're gonna take him back, and then we're not gonna bring Brown just yet. I'm gonna run Hawk. She's gonna go talk to Brown.
And when you get a second, I'm gonna need 7 exhibit schedules.
On the record in the matter of the people of the state of Michigan versus Jeremy Lee Hawks, file number 24-00111, council appearance.
Prosecutor Paige Petrowski on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Hawks. He is present to my right at council table.
How are you, Mr. Hawks?
Nervous.
Reasonable under the circumstances. Nonetheless, you are in good hands. You have an attorney with you. Today was the date and the time that was set for a preliminary examination. I have one count of assault with intent to do great bodily harm, less than murder, and then I have domestic violence. Are we ready to proceed?
Yes, Your Honor.
Preliminary matters before we call witnesses.
None from the people, Your Honor.
Nothing preliminarily on behalf of.
Call your witness.
Other people call Emily Richardson. Yes, Wilson, good.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. I do. You can have a seat there, ma'am. Okay, there's a microphone that's in front of you, and the lady behind you is the court recorder. She has to take down everything being stated here today. So I need your responses to be loud and clear, and they also must be verbal, okay? And then if there's an objection from either attorney, you would stop speaking immediately. I'll make a ruling on that objection. Then I'm gonna tell you if you can give that response or not. Okay?
Okay.
Okay, you can't do head nods and shakes only. We'll just ask you, is that a yes or no? Because we need to be able to articulate it clearly in the record, okay?
Yes.
Can you spell your first and last name?
MileyRicharson.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Ms. Richardson. How are you doing today?
Good, thank you.
Where were you on the evening of January 15th, 2024?
So I was with Jeremy Hawks at his house on Magnolia. I'm sorry, I don't know the full address.
You know, what does 328 Magnolia? Is that
Yes,
correct?
yes, that's correct.
Is that in Lansing?
Yes,
Ingham County,
yes, it is.
in the state of Michigan?
Yes, it is.
And do you live there?
I do not.
Who does?
Jeremy Hawks.
And how do you know Mr. Hawks?
We met online 2.5 months ago.
Okay, and what's your relationship?
We were dating, and then December 25th, he proposed to me and we got engaged. So fiance at the time instead.
And do you see Mr. Hawks here today?
Yes, I do.
Can you describe where he's sitting in an article of his clothing?
Yes, he's sitting on my left and he's wearing a black suit jacket.
Let the record reflect that Ms. Richardson has identified the defendant.
Any objection?
Without objection.
Identification is noted.
So you were visiting Mr. Hawks?
Yes, I was.
And were the police called that night?
They were, yes, they were.
Why were they called?
They were called because of a domestic assault. Mr. Hawks called the police. I did not have a phone or keys to be able to make the 911 call. So he made it after somebody came to the door after I yelled for help. And then he called them, the police.
So I kind of wanted to get back to earlier in that
Yes.
evening. So what were you and Mr. Hawks, what were you guys doing?
So the day started out fine. We went to the mall, we went to a bookstore, and then we went to it was like a Dave and Buster's. I can't remember the name of the place. And then we ended up going home. I got a bottle of wine, he had some whiskey, and we decided to play cards. I made salsa and everything was going fine. So we were drinking, Mr. Hawk was drinking whiskey. We were talking, and then all of a sudden the conversation got a little bit weird. But Mr. Hawks is, his conversations were interesting, so I didn't think anything of it at the time, but he asked me if I had ever been to hell. And I said, well, I feel like we probably all have at some point had hard moments in our life. And then he said, no, really, have you been to hell? And so I said, well, it's kind of a weird conversation, so I got uncomfortable, so we moved on. So then we continued playing cards. And then, sorry.
Yeah, it's nerve-wracking.
Yeah.
So
Yeah.
here, I'll
Yeah,
cut in a little bit.
yeah.
Did things take a turn from just weird conversation to something more serious that night?
It did. Yeah, it did.
Can you tell me what you remember about when things started to shift?
Yeah, so we continued playing cards, and then later on in the evening, I don't know exactly how the conversation started, but it was a conversation about, he asked me if I had any like felonies or priors or like charges, and I laughed and I said, well, no, because I work for the federal government, I can't have a record. And he just got kind of weird about it, and was, we were kind of, I thought it was a joke, we were laughing about it, but I thought, I had said to him, like, it's a little bit strange that you're asking me this. And then he said to me, okay, well, I'm gonna go out for a cigarette. And I'm like, okay, that's fine. And I was gonna go into the kitchen to make something else to eat. And he headed to the door, and by the door, there's a dresser that didn't fit in his bedroom. And on the dresser were his, his phone, his wallet, a handgun with clip, bullets in it.
Can you describe what that handgun looked like?
It's white. I don't know much about guns, I'm sorry. It's only a small gun. He used it, he said, because where he lived was dangerous. So I was never really, there was never really any, I was never worried about it or anything, because it's not, I'm told that's common. And but he headed to the door and grabbed the cigarette and picked up the gun and put clips in the gun, like put the clip in the gun.
Like he loaded it?
Yeah.
Okay.
And then pointed it towards me.
And sorry to interrupt. When you say towards, do you mean at
in
you,
the
or
vicinity? And I said, you know what, I don't like that.
how did it, what was going through your head when he pointed the gun towards you?
At the time, I've never had any issues in the past with this. Like, there was never any issue. I just said I don't like that. So then he started getting.
Oh, I got a couple more questions about that.
Of course.
You're good. So when he was pointing the gun towards you, could you see where his hands were?
So he was still holding one of the cigarettes. So they're one hand was holding the gun up, and the other one he had the cigarette.
Could you see his fingers?
Not really, because I at that moment was kind of more just it freaked me out. So I kind of looked at him in the eye and I said, no, I don't like that. I don't, no.
And why did it freak you out?
Because it was in my direction. In Canada, people don't have we don't have handguns. We don't do that. So it was kind of, it threw me off. It was just an uncomfortable situation. We weren't arguing, we weren't fighting. But then when I said I don't like that, that's when things turned. So Jeremy he put the gun down, he started yelling at me and telling me that I wasn't gonna call the police for threatening me with a gun. And he said, you're not gonna ruin my life like the other bitches.
No, when you were saying that he was saying you're not gonna call the police.
Yeah.
Did he say to you, you're not gonna call the police for me threatening you with a gun?
Yeah.
Did he use the word threaten?
Yes. Yeah. So at that point, I felt that this is where like Jeremy wasn't himself. Like we had an argument previous, like a month or so ago. Just angry, just like an anger, screaming, yelling. So I just thought this is what it was gonna be, and I said, I'm not gonna call the police. I just don't like that. But then it continued. Like he was just yelling and screaming, and he grabbed my phone and my car keys and threw them outside. And there was just a lot of, like, at that point, there wasn't any, it was just more verbal.
Yeah.
He was calling me names, telling me to go back to Canada. That just over and over kept telling me that I wasn't gonna call the police, that I was a bitch, that I was gonna ruin his life. And I said, I'm not gonna call the cops. And at this point I'm crying because like he's just screaming, like he's just going crazy. So I said, like, where are my car keys and my phone? And he took me to the door and he's like kind of was laughing. He's like, there, he's like, your car keys and your phone are outside. He's like, go get them, that's your whole life right there. And I said, it's just my phone. I said, but like now you're, it's outside in the snow. So I was worried at that point to go outside to get them because I was wearing like just like a long sleeve like t-shirt and leggings, exactly. And I think it was like -15. I don't know what that is.
Oh yeah, Celsius to
yeah. So it was. So my concern was that he was gonna lock me outside.
Okay.
And at that point I had been drinking, so I didn't want to drive. So I said, okay, like, I was crying and I'm like, why would you throw them out there? And he just kept saying over and over again, go get your phone. He's like, that's important. And he's kind of laughing at me, kind of making fun of me. So I went out and got the phone. He did close the door. So, at that point I didn't really know what to do. So he opened the door again and he said to me, he's like, come back in and get your shit. He's like, and get, the fuck out of here. And I'm like, well, I've been drinking, I can't drive. And he said, I don't really fucking care. So then I went inside and I was gonna, gather my stuff. And then he started throwing the rest of my stuff out the front door, like my clothes and my bag and stuff like that. So I went and got that stuff, and again, still taunting and laughing and calling me names. So I grabbed all that stuff. At that point, Jeremy was laying on the bed, on the sofa. So I thought, okay, well, I thought maybe he was falling asleep. So I went into the bedroom and I closed the door and I'm like, okay, I'm gonna leave in the morning. So I took my ring, I put it in the kitchen counter, I went into the bedroom and I locked it, I closed the door. So then at that point, I had to go to the bathroom. So, and I don't know why I did this, but I took my phone and my keys and I put it under a pillow on a desk, like a bureau in the bedroom. And I went upstairs to go to the bathroom. Jeremy, I think, was sleeping. I thought was sleeping. And I came back down and went to grab my phone and my keys and they were gone. And I specifically remember putting them there because if I was going to leave in the morning, I wanted to make sure that I had that. So when I came down, they were gone. I went to Jeremy and I said, where are my phone and my keys? And he's like, I don't have them. I'm like, well, you must have them because I had them. They're not there anymore. So at that point, he was calming down. Like he was, so that day, so the 15th, was his son's birthday. And so doesn't have custody of his son. So I knew that at that point, like maybe it was a hard day for him. So I sat down on the sofa and I said to him, I realize today is a hard day for you. I'm really sorry. I realize it's Jace's birthday. And I said, I love you. I'm sorry you're hurting. That's when he lost it. It was like somebody I didn't recognize. He just kind of blanked out and he sat up and he lunged at me
So, oh, really?
Yeah.
You're good.
Yeah.
So, before when you were saying like, I love you, and today's hard, but you were on the couch and he was on the couch?
He was laying down and I was sitting right at the other end.
Okay.
At that point, I knew I had to leave the next day, but I wasn't, because I had never had this moment with Jeremy before. There was never any indication that he would hurt me. He was always there were never any issues.
Yeah.
So for me, I wasn't worried at that point. The gun issue at the beginning was very concerning, but I thought, it's, we've dealt with it, it's fine. So he's laying down, I'm sitting here on the other end of the sofa. And when I said that, he sat straight up and he grabbed me by the hair.
Okay.
And he threw me to the ground and my head hit the floor. And he said to me, "You're a sick fuck for threatening a 2-year-old." And I was very confused because I didn't say anything. I just was trying to validate the feelings that he was upset, and I recognized that it must be a hard day. So he just said that over and over and over again, that I was, a sick fuck for threatening a 2-year-old. How dare I? There's something wrong with me. So he grabbed me by the hair and he threw me on the ground. And at that point, he kneeled on my arms.
And when you say your arms, you're kind of putting it into your shoulders?
My shoulders,
Okay.
sorry. And he put his forearm on this part of my neck.
Okay, and you're gesturing kind of under your...
Just under the Adam's apple.
Okay.
And then at this same time, he's just saying it over and over again. And I can feel him putting his weight on my neck. And I'm not I can't breathe. I'm not getting any air at all.
And you were trying to breathe?
Yeah.
Okay.
Yeah. And I know so one of the injuries, my fingernails were bruised because I was trying to release that grip. So sorry.
Okay, if you need a tissue or something,
Yeah,
we can get you. Okay, just let me know. No, you're fine. So when he had his arm on your throat, what were you thinking in that moment?
I think it was more just to get away. I was I was starting to get lightheaded. So I don't know how long it was, but I do know that it was starting to I was feeling there was some lightheadedness. So I was concerned that I was gonna pass out. So I managed to do, somehow I managed to get out and turn my body. So then his forearm was on the side of my neck, just under my ear.
Okay.
So at this point I could breathe and I managed to push him off. So I stood up and then he grabbed the back of my head again. Once I was standing up, he grabbed it because I was trying to get out towards, so all of this happened in the living room. So it's the living room, and then there's a little eat-in area, and then there's the kitchen and the back door. So all of this, most of this was happening in the living room. So when I got up, I tried to get towards the back door, and he grabbed my hair again and pulled me down. And this time he smacked my head on the hardwood floor twice. So he hit me once and then lifted me up again and hit me again on the hardwood floor. So then, sorry, at that point, it's, yeah, that's
so so a lot's been going on. What are you feeling emotionally when you're going through this?
I think it's at that moment I was just trying to keep my wits about me. I was fighting back, so I think I was just focusing on like protecting myself. And the one thing which I've been processing this a lot is that I thought that I didn't want to like hurt him, but I think it was more that I was concerned that if I did something to hurt him, that was going to cause more serious damage to me. So I think it was more about just trying to fend him off and get out, like get away.
Yeah.
You know, and that was like, yeah.
No, no need to apologize. So when you're defending yourself, what types of things are you doing?
I think I'm more just using my force. So like I'm just
moving your
like,
arms.
Yeah. Like I said, one of the things that like even now still they're a little bit sore, like was fingernails. Like I mean, I don't have much fingernail, but you know, just trying to like, I know that at one point I managed to grab him and dig my fingernails in. Just trying to defend. Yeah.
And while you're trying to defend yourself, is this while he's still trying to choke you, or is he doing other things?
He's doing other things. So like
kind of things?
Grabbing me, like he pulled my hair a lot. Just like from like the back, the top. One of the things that happened a little bit later on in the evening was I managed to get to the kitchen, and I don't know what prompted this, but he I must have, I don't know why, I turned around and he was coming at me and he grabbed me by the face. So I had marks here, all here, and I had this massive bruise. He grabbed me by the face and he pulled my face and slammed me on the floor by my face. And I don't know, from like at that moment, I don't know. I managed to get back up. And just through the whole thing, he's just yelling about this thing that I said about his son. And the weirdest thing is that during that moment, I started thinking, like, did I say something? You know, because I felt like he was just saying it over and over, that like I felt like he was putting in like I was like, maybe I did say something, like, but I couldn't remember, you know, like to have this happen, like I must, you know, I messed up. So that like pull down by my face, that I don't, like after that, I don't really remember. I managed to get back up. Somehow we ended up back in the living room, and I'm
sorry, what is the question? Because she's doing a narrative. I was waiting for an objection, but I didn't get one. What's the question?
Oh yeah, I was asking her to describe the as the assault continued, but
okay,
I can.
Thank you.
Clear it up. Yeah. So you said that you were standing up again?
Yes. Yeah.
Did you I know you had went outside to get your keys and things. Did you try to go outside again?
He wouldn't let me.
What do you mean by that?
I never got the opportunity to get to the door, to get outside. I mean, I had been outside to grab my keys at the beginning before the assault happened. So I grabbed my clothes, grabbed my keys, and at that point we were settled, you know, Jeremy had settled, so I wasn't overly threatened. But at that point, I didn't get outside until right at the end.
Okay, let's talk about that a little bit.
Yeah.
So when did you just walk out the front door?
No. So at that point, I had managed to get to the back door. I opened the door and I saw that there were two people standing across the street. When I saw them, I yelled for help very loudly. And then Jeremy came up behind me and grabbed me by the hair again and pulled me back inside. And at that moment, he turned the lights off and slammed the door shut. And then I like somehow got back to the door and he was holding it shut, but I got the door open and I turned the lights off and on, and there was a girl standing right on the doorstep, and Jeremy told her to, you know, get the fuck off this property, and she basically said, I'm not going anywhere. So then at that point, that's when Jeremy called the police.
Okay. Yeah. So when you're saying that he You said he pulled you back inside?
Yeah.
And turned the lights off?
Yeah.
Did you want to go back inside?
No. No.
So once, sorry. So does anything else happen after he says that he's calling the police or is calling the police?
So the police instructed that I wait outside. So I waited outside with the girl that was there. Jeremy shut the door, and at that point, I just waited for the police to show up. Yeah. At that point, there was a situation. So my keys and phone were gone. So the keys were inside, was unlocking and locking my car. So I don't
I will
know.
object, it's non-responsive at this point. I think she's already answered the question that was initially posed.
Objection sustained.
So, so you spoke to the police that night?
Yes.
What did you do after speaking with the police?
So after I spoke with the police, they suggested I leave and get a hotel. So that's what I ended up doing.
Okay. How were you feeling physically after you left, when you left the residence for the night? How were you feeling?
So driving to the hotel, I think, adrenaline. But when I went back and got a shower, and then I was in a lot of pain.
Where were you feeling pain?
My head, from the pulling, my face. So my face was really sore. I had an injury on here.
You're gesturing to the side of your hand?
Yes, the side of my right hand. I thought maybe it had been broken. I had a large bite mark on my left forearm. So here and here, so top and bottom.
And and just because I don't think.
When
did you receive the bite mark?
So,
or if you could describe.
Yeah. So there was a moment when I was in the kitchen, and I think I was fighting Jeremy off, and I had my arm out trying to push him away, and he bit on my arm and bit hard, and then pulled his teeth off of my skin. Yeah, so that's when I received it.
Okay. And then either like that night or in the following days, did you notice any like raspiness in your voice or any coughing or anything?
Yes.
Can you talk about that?
Yeah. So there was more, it was more like pain. I had trouble swallowing solid foods for 3 days. My teeth were sore. Even to this, like today, I'm having, like, I still have a little bit of pain right here.
Okay.
Yeah.
And then in the days following the assault, did you have any bruises?
Yes.
And did you take any pictures of your bruises?
Yes.
Do you know when, like how many days after you took those pictures?
So there are a set from the day I went to the hospital, which was Tuesday night when I got home from Michigan, when I drove home. And then there were a second set of pictures the second day.
Okay, so that'd be that Wednesday.
So Wednesday. Okay. Yeah, because there were more bruises showing up over time.
Okay.
Yeah.
So I'm going to show you a couple of pictures, but one of them's on the ground. So permission to approach your eye? Yes. So I'm showing you People's Proposed Exhibit number 1. Sorry. So you recognize what's in that photo?
Yes.
And how do you recognize it?
So it's my right hand, and that's the injury to the side of my hand. That was the concern of there being.
Yeah. I'm gonna get into that in just one second.
Sorry.
So was this taken on the Tuesday or Wednesday?
That was taken on Tuesday night at the hospital.
Okay, and that was, I'm so sorry, I got my days. Is that what,
Tuesday the 16th.
60, also 1 day after the assault?
Yes.
Okay. All right. And is that picture accurately represent what your hand looked like on the 16th?
Yes.
The people moved to admit people's exhibit number 1.
Any objection?
Without objection.
People's 1 is admitted.
So now we can get into, so you were saying, so this is depicting an injury on your right hand?
That's correct, yes.
And can you kind of just describe what that looks like? Just because the record
Yeah.
needs the.
Yeah, absolutely. So it looks like so it's a bruise on the side of my hand.
Okay. And did your hand look like that prior to the 15th?
No.
Okay.
No.
And it doesn't normally look like that?
No, it does not.
And I'm gonna repeat this routine here. So I'm showing you people's proposed exhibit number 2. So what day was this one taken?
That was taken on the Wednesday.
So the 17th?
17th, yes. Yes.
And you recognize that picture?
I do.
And does it accurately represent what your what you look like in the 2 days after the assault?
Yes. It does.
People moved to admit people's exhibit number 2.
Any objections to people's 2?
Without objection.
People's 2 is admitted.
So can you describe this picture for me?
So it's my left leg. There's bruises on my knees. I do want to say that cut is not from I had that previous.
Thank you for that.
Yeah, so there's bruises on my knees. There are bruises on the side of my knee. And there are bruises down a little bit further on my leg.
And your leg did not look like that prior.
No.
And do you know the specific like part of the assault that would have caused these bruises, or is it just kind of?
I know that I don't know when that happened. I know that I was thrown around a lot, so I'm sorry. Yeah,
No,
I don't.
no need to apologize. I'd rather you tell me if you don't.
Yeah.
People's proposed. So this is people's proposed exhibit number 3. Do you recognize this photo?
Yes.
What day was that picture taken?
That was taken on Wednesday.
2 days after?
Yeah.
And is that an accurate representation of what looked like 2 days after?
Yes.
People move to admit people's exhibit number 3.
Any objections?
Without objection.
The 3 is admitted.
Yeah, can you describe what's that picture of?
Yeah, that is underneath my arm here.
Okay.
And yeah, it's a bruise from my elbow down. Again, I don't know I don't know how it happens, but yeah.
And does your arm normally look like that?
No, it doesn't.
Actually, I'm going to hand you people's proposed exhibits 4 through 7, just to save us some of the process here. Right. So these 4. If they're all taken on the same day, let me know. Otherwise, let me know which day each one's.
Yeah. So this one was taken on Wednesday.
That's number 4. Okay,
Yes.
so 4 was on the 17th.
That's right.
Okay.
Um,
And then what about the other?
so this one was at the hospital. So that was Tuesday.
Okay.
This
Those are
one-
for proposed exhibits 5 through 7.
so, yeah,
Oh, you're
Which one was that?
exhibits 5, 6, and 7.
we're at the hospital.
And do those 4 pictures accurately represent what you look like, either on the 16th or the 17th, depending on?
Yes.
People move to admit people's exhibits 4, 5, 6, and 7.
Any objection?
Without objection.
People's 4, 5, 6, and 7 admitted.
So let's start with people's exhibit number 4. Can you describe what's in that picture?
Yeah, so this was my left forearm. That is, did you want me to-
Oh, yeah, go ahead, just, yeah.
That's where Jeremy bit me. So there's another one where you can see the bottom part of his teeth underneath. So he had bit around and pulled. So that's what that represents.
And then let's look at exhibit number 5.
Yes.
Describe what that's a picture of.
So that is a picture of my face. So the left side, that's where Jeremy grabbed me like this.
Okay, so you have your finger kind of positioned in about
Yeah.
around your eye.
Yeah, and then like right on by my cheek, by my mouth.
Okay.
And then there's another picture that isn't, and there's a big bruise here from where he had grabbed and pulled me down. Yeah.
And does your face normally look like that? Let's go to people's exhibit number 6.
So, oh, yeah, so this is my lip. So that is when Jeremy grabs me, somehow it was cut because it's with the grab, it was like an open hand. So he kind of like hit me with his open hand and then grabbed my face and pulled me down. So that is where like I cut my lip on my teeth.
Okay.
Yeah.
And then people's exhibit number 7.
Okay, yeah. So that is the side of my face, and then the bruise on my neck, and then back here on my neck. So that's a series of things. So that was the strangulation, and then that one was the grab and the pull down.
Okay.
Yeah.
What is something that you just will never forget from that night?
So there was a situation, I don't know if I
I'm
can.
gonna check. I think that's a rather vague question.
I agree. Okay, rephrase your question.
Yes. I'll just ask a different entirely. I'm actually, yes, of course. Yeah, actually, and I'm all set, so no further questions.
Okay, you can publish the exhibits.
Oh, yes.
Cross-examination.
Sure, thank you. Morning, Ms. Richardson. I understand your testimony correctly. You did not call the police.
I did
that
not.
night, correct?
Absolutely.
Mr. Hawks called the police.
Yeah.
And you stated you had been consuming alcohol that night as well, right?
Yes, that's correct.
And were you drinking wine?
I was drinking wine.
Were you drinking anything else other than
I
wine?
was not drinking.
How much wine did you drink and over what period of time?
So we started drinking early, so it was probably when we got home, it might have been around 5 o'clock.
Of an evening?
In the evening, yes. And so we were consuming wine through the evening. I was consuming wine through the evening. Mr. Haas was drinking whiskey. So yeah, so it was over probably a 3.5, 4 hour period.
You know how much wine you'd consumed that evening?
I just had a bottle of wine, so 750 milliliters.
And you talked a little bit about there was a point where Mr. Hawk started engaging in some type of weird conversation.
Yes.
Right?
Yeah.
And after that, the two of you just went back to doing what you were doing, playing cards and so forth?
Yes.
Okay. And I want to talk to you a little bit about the handgun you talked about earlier. So initially, as I understood it in your testimony, you'd indicated that maybe he pointed it towards you, but then you said, I believe, in the vicinity or in your vicinity.
Yes.
What do you mean by that?
So it wasn't that he, came close and had it, like this, but it was in my, it wasn't off here or here, it was in my space, my space.
Okay.
Like, I don't know how else to explain it.
And in other words, when you were gesturing just a moment ago, when you started to answer my question, you said he wasn't doing this, and you had kind of indicated pointing straight at your face.
Right. Yeah.
So in other
he
words,
was not doing that.
Okay. So Mr. Hawks did not point the gun directly at your face then, correct?
No, but when I say vicinity, like in my vicinity. So I was very uncomfortable with him having it up towards me and loaded.
And Were you actually able to tell whether it was loaded or not, or is that just something you were presuming?
No, because I know that there were bullets in the clip because I had seen it on the dresser. And I don't know much about guns, but he took the clip and pushed it into the gun.
And the whole situation where you said he was pointing the gun in your vicinity, how long are we talking here? Like a second, a little more, a little less?
It might have been a little bit longer than a second. Yeah.
And what is the distance between you and Mr. Hawks at that point?
So I'm in the living room, like I'm in the dining room and Mr. Hawks was at the back door. So I'm so bad. It's like 20 feet. I don't know, 30 feet maybe.
Okay, so good considerable distance in other words. Okay. And after that occurred, you did not leave the house at that point, is that right?
No, so that was the first incident where
Okay, and that answered my question.
Yeah, okay.
And you did not call the police at that point?
No, I
correct?
did not.
Okay. And at some point you were talking about, you were outside, and I think you said you saw, was it 2 people across the street?
That was right at the end of the evening, so after the assault had taken place.
Sure. And you said there were 2 that you noticed?
Yes.
Like male or female?
So I didn't notice because they were across the street. I didn't notice at the time if they were male or female. I only knew it was a female when she got to when we opened the door the second time and she was standing there.
Is that one of the 2 people that you initially saw?
I'm assuming so, yes.
Okay. But you can't be for certain?
Not 100%.
Okay. Whoever this person was, you did not know this person,
I did
correct?
not, no.
Okay. And at some point after Mr. Hawks called the police arrived, is that
They
right?
did.
Okay. And you remained there and spoke with them?
I did.
Okay. And they were asking you questions about what had occurred?
Yes.
Okay. And you were doing your best to recount to them what had occurred as best you could recall it?
Yes.
Okay. And you told the police about the argument that had started something regarding Mr. Hawks' son, is that right? Okay. And did you mention at all to the police about the gun?
Yes.
Isn't it true you never mentioned anything to the police about Mr. Hawks pointing the gun?
So I don't know if I can say, there was a second situation with like another gun.
Well,
yeah.
Well,
So I spoke to the police about the other gun, not the handgun.
okay. So then to answer my question, you never told the police about Mr. Hawks pointing a gun, is that right?
I did mention that he pointed the gun, yes.
And whatever the conversation was regarding Mr. Hawks's son, you said that seemed to upset Mr. Hawks?
Yes.
And would you describe him as being emotional over that?
So I guess in the terms of emotional being angry, then yes.
It seemed to sadden him at all?
No.
And you stated at some point that you went to the hospital.
Yes.
And what hospital was that?
It was St. Joe's Urgent Care in Hamilton, Ontario, Canada.
That's where you reside, correct?
Yes.
And who took the various photographs that we saw depicted here today?
So the pictures are ones that I took. And then the second set were ones that I took.
And you talked about at some point, I think you were in the house and you'd locked yourself into a room or a bedroom, is that correct?
Yeah, I had closed the door.
Where was this in the sequence of events as it relates to the, you said the pointing of the gun incident?
Yeah,
Just
so
before or after?
so this was after. It was after, yeah, after that.
Okay. And when you locked yourself in that room, you still had your phone and keys at that
At
point?
that point, yes.
Have a moment, Your Honor.
Yes.
And how did you lock the door? Was that with a doorknob? Was that with a latch, or how did that?
So I didn't say it locked, I said the door, I closed the door. Yeah, I never said it locked.
I think, I thought I heard you say that
No.
earlier in your testimony. Maybe I
No.
misunderstood.
No,
Okay.
no.
And you didn't barricade the door or anything like that?
No.
Okay. Thank you very much, Mr. Chief.
Redirect.
Yeah, just briefly. So when Mr. Hawks was you said putting the gun in your vicinity, you said that you one of the words you used to describe it was uncomfortable.
Yes.
What type of uncomfortable?
I guess I just unpredictable, like the situation was unpredictable. I don't know what could have happened accidentally. We were both drinking. So, I just mentioned how I was feeling and how it was just an uncomfortable situation.
Were you scared?
Action leading?
The objection was that the question was leading. You rephrase it.
What emotions were you experiencing?
At that point, because Jeremy and I hadn't had any violent situations, I wasn't afraid that he was going to intentionally do something. I was worried more about there being something accidentally happening because we were both drinking, and so I think, yeah, just uncomfortable and yeah.
And then when you spoke to law enforcement when they showed up, did you want Mr. Hawks to get in trouble?
Not at that moment, no.
Objection, relevance.
There's been some discussion about whether she did or didn't bring up incidents with the gun. So I think getting into why she may or may not have made those comments at that time speaks to her credibility.
Objection overruled. You can answer the question.
Oh, okay. At that time, like, I think I was just, like, I was so out of sorts, and it was just like a very emotional situation that I didn't bring up that specific situation. But like I said, there was another situation. So yeah.
No further questions.
I have a question, because I'm still not clear on the testimony regarding the pointing of the firearm. So let's say you're here, this is you on the alleged date, and let's say Francis, raise your hand, please. Let's say that is, I'm sorry, you're going to be Mr. Hawks. Francis, where she is going to be you. I want you to demonstrate, take this pen, demonstrate what you mean about he pointed the firearm in your vicinity.
So when he picked up the gun and put the clip in, it was like, so it was like this, and he put the clip in like this.
Okay, so the record should reflect that you're holding up the pen in your left hand or right?
Sorry, yeah.
In your
so-
right hand.
Yeah.
That the barrel of the pen was pointed in the same direction that you were
Correct.
standing as he inserted the clip.
Correct.
Okay, and so was it your belief that he was intentionally pointing that in your direction, or that he was just loading the clip?
I felt that kind of how things were going, he was like laughing and loaded the gun. I felt that I didn't feel like his intention was to shoot me, but I thought that it was like, it felt like it was in his intention to point it in my direction.
Okay,
Yes.
sounds good. Any redirect or cross based on my question?
When he was loading it and putting it in, was he saying anything to you at that time?
Not at the time, no. There were no, it was just more of like laughing.
Okay.
Yeah.
No other questions, no further questions.
Mr. Austin, any question?
No, Your Honor, thank you.
Thank you. May this witness be excused?
Yes, Your Honor.
Thank you. You may be excused.
Thank you.
And people will be calling Officer McKeedy.
As to what elements are you trying to get more testimony for?
I was just going to have him.
Come and tell us what you told him.
Yeah, okay, sorry, sometimes dot the i's, cross the t's.
No, you can make it a lot easier. This is a preliminary examination, so a lot easier than, we don't need all the necessary witnesses. If you got all the elements. Any other witnesses?
No, Your Honor.
Any witnesses from you, Mr. Austin?
We'll rely on the evidence presented, Your Honor. Thank you.
Argument.
Thank you, Your Honor. The testimony from Ms. Emily Richardson today very clearly lays out the night in question, January 15th, 2024. And she gave a very detailed recount of what exactly happened that night. She was able to testify to the fact that the defendant in this case did in fact commit a strangulation or a suffocation of her. She was unable to breathe. She was getting lightheaded and dizzy. Her voice was hoarse. She was in a lot of pain. And this was against her will and done intentionally by the defendant. Additionally, the testimony has indicated that the defendant also committed an act of felonious assault on the victim because he did an act that would cause a reasonable person to fear or apprehend immediate battery. In this instance, loading it while loading the gun, pointing it at Ms. Richardson. Although it was not pointed at her for long, she was under the impression that she was being threatened. And then later by defendant's own statements made to her, he was telling her, don't go calling the police because I was threatening you. Those indicate that it was a voluntary act done with a weapon. and that the defendant believed that he had the ability to do so, given that he was loading and pointing the gun. Additionally, the testimony has established that defendant has also committed the offense of a felony firearm, and that he had committed the felonious assault while pointing the weapon, the white handgun, at Emily Richardson, because he knowingly carried or possessed the firearm at that time when loading and threatened her with it. She also testified to the fact that this took place at the address of 328 Magnolia Avenue in Lansing, Michigan, Ingham County. And as such, I would move the court to bind over on the assault with intent to great bodily harm or by strangulation as charged, as well as the additional counts of felonious assault and felony firearm.
Ms. Ryan.
Thank you, Your Honor. Obviously, we heard from one witness today. The court is the sole determiner of credibility, even at this stage, where the burden is probably the cause of a much lower burden and proof beyond a reasonable doubt that people have to prove a trial. Nonetheless, the burden that they must meet. I can understand the way the testimony played out if the court believes that there is probable cause to support the initial felony charge of the great bodily harm strangulation. As it relates, though, Your Honor, to the people's request to add the additional felony counts of felonious assault and felony firearm, I think there's a few key points from Ms. Richardson's testimony I would ask the court to focus on when making its determination. I think the language that the gun was being pointed in her vicinity from quite a distance away for a very short period of time, I think is significant. Also, what Ms. Richardson stated is that she did not believe that Mr. Hawks was trying to intentionally harm her, that he was not intending to shoot her. She may have been in fear that something accidental would happen, but I think for the elements for felonious assault to be met is that there would have to be the intent by Mr. Hawks to place her in fear of some type of assault or imminent battery with the firearm, and that the victim was in fact placed in such fear. And I think the way the testimony played out is that she was not in fear that Mr. Hawks was about to commit some type of battery on her, which would be some type of intentional act. She may have been afraid something accidentally or maybe negligently could have occurred to her to cause her harm, but I don't think that places her in fear of a battery, which is going to be a necessary element for the felonious assault. And likewise, if the proofs fail on that count, Your Honor, there would be no felony firearm attached to that count. So given all of that, Your Honor, I would ask the court to deny the people's request for bind over on all counts today. Thank you.
Thank you. Today was a date set for preliminary examination. The burden is squarely upon the prosecution to establish sufficient probable cause, and that's probable cause that a crime was committed and probable cause to charge you, Mr. Hawks, with the crimes. The standard only applies in count one because that's the felony. Count two is a misdemeanor. We do not need to address probable cause for that purpose. The people are asking to add two additional accounts, that being a felonious assault and then a felony firearm account. Again, this is not a trial. A trial, they need to prove each element beyond a reasonable doubt. Today, the burden is more than mere suspicion that a crime was committed, and the evidence is weighed as is presented today at the hearing. I am, again, as your attorney indicated, the sole determinant of credibility, and then I will also weigh the prosecution's probability of success at a trial. We had testimony today from one witness, that being Emily Richardson, the alleged victim in this matter. She testified that on January 15th, 2024, she was at the defendant's address, or the person she identified as the defendant being Jeremy Lee Hawks. She wasn't 100% clear of the address, but because she's not from here, but she was refreshed and indicated the address being 328 Magnolia, City of Lansing, Ingham County, State of Michigan, which makes venue in this court appropriate. She testified that she had been dating the defendant, that they had met online, and that at some time during the month of December, around Christmas, he had proposed, and they were at the time engaged. She did not live or reside in the defendant's address, that she was here visiting the defendant. And they had gone on a date, they'd come home, they were engaging in some consumption of libations. I think he was drinking whiskey, she said she was drinking wine, that she made some salsa, they played some cards, and that she was going to go get up to go make some more food when the defendant made or questioned her about whether or not she had ever been to hell. She said that that was something that she thought would to be concerning or peculiar, and that she responded to him in a way that she deemed fit, that he continued to ask her a question along that lines, which she found to be concerning. She said as he got up to head out to go get a cigarette, that she observed the defendant pick up his firearm, and that she observed him to load the clip into the firearm, and that the firearm was pointed, or the defendant pointed the gun in her vicinity. She indicated that she told the defendant that she didn't like that, and that caused the defendant and her to go back and forth in an argument, and that he started yelling at her, and that he threw her keys and phone outside in the snow, began to call her names. She said she had a concern about going outside to gather those things at his direction, because she thought that he would lock her out, and it was sub-zero wind chill factors on that date in question, and that she had been drinking and she didn't want to drive, and that she was only wearing leggings and a t-shirt. She said that she recognized that that date was the same date of the defendant's child's birthday, that she indicated to the defendant that she understood this may be a tough day for him, and that she was sorry that he was hurting. She said at that point the defendant lost it and lunged at her, that he grabbed her hair, threw her on the ground, that he kneeled on the victim's shoulders, placing his forearm around her neck. She stated she began to feel pressure and that she couldn't breathe, that the victim said she used her arms to try to defend herself, at some point grabbing or digging her nails, or what she has. She said she indicated to the court by showing her nails that she didn't have much nails, but attempting to dig her nails into the defendant. That the defendant pulled her hair a lot, that he grabbed her by her face, pulled her face down and slammed it on the floor, that she was able at some point to break away. She said she opened the back door. She saw two people across the street and yelled very loud, that the defendant grabbed her by the hair back into the house, shut the lights off, and she was somehow able to get the door back open, that the defendant was the one, she testified in the beginning, to call the police, that she left at the advice of the officers. After speaking to officers, she got a hotel. She reported back home and went to the hospital. She reported pain in her head, her pain in her face, injury on the right side of her hand, or side of her right hand. She said a large bite mark on her left forearm. She indicated she had trouble swallowing solid foods for several days. Her teeth were sore, and that there were People's Exhibits 1 through 7 that were admitted to reflect the injuries that she allegedly sustained as a result of this incident. count one of assault with intent to do great bodily harm, less than murder, or by strangulation would require the people at the time of trial to prove beyond a reasonable doubt, first, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believe that he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means a physical injury that could seriously harm the health or function of the body. This was charged as assault with intent to do great bodily harm, less than murder, or by strangulation. The elements that the defendant testified to support that would be being grabbed by her hair, she states, and thrown to the ground, and that at that time that the defendant allegedly placed his knees on her shoulder, describing her being pinned down, and his forearm around her neck, and that she felt him applying pressure and that she couldn't breathe. As to count one, the court is satisfied that there's sufficient probable cause, and that will be bound over to the circuit court. The people are asking to add a count of felonious assault based on the victim's testimony, and the defense counsel is objecting to that. The portion of the testimony that the people are relying on is the testimony from the victim indicating that the defendant pointed the firearm, a loaded firearm, in her vicinity. The court provided the victim with the pin and asked the victim to describe that interaction, to which she demonstrated that the defendant picked up the firearm as the firearm being pointed in her direction, not just in her vicinity, but in her direction as he loaded the clip. The court then questioned her about whether or not she believed that that was an intentional act. She indicated that it was not her belief that he was intending to point the firearm at her, but her indication or her feeling was that it was somehow threatening or concerning to her. The other things that the court must take into consideration as it relates to probable cause as to adding a count of felonious assault is the testimony about the statements that was made. The victim testified that after he pointed the firearm in her vicinity, that she indicated to him that she doesn't like that, and that's when things got bad, and he started yelling at her and told her that she was not going to call the police for him threatening her, and that you're not going to ruin my life and call the police for me threatening you with the firearm. If true, those statements, if said, would cause the court to have more than sufficient probable cause that the firearm was placed in her vicinity as a way to threaten her, or to cause a reasonable person to feel threatened. With that being said, the court is satisfied that there's sufficient probable cause to add count three of a felonious assault felony firearm allegation that the defendant used firearm in commission of a felony will be added. These counts 1 through 4, count 2 again not needing to be addressed for probable cause purposes, will be bound over to the circuit court for a bind over date of February 14th. Mr. Hawks, you do not need to appear in court on February 14th. That's the date the circuit court will get the file from the district court, okay? Okay.
Just ma'am.
Your next court date will be in circuit court. It will be for a pretrial. Mr. Austin will be made aware of that. You stay in contact with him, okay?
Is there a date for that?
No, he'll be notified from the circuit court after they receive this file.
Yes, ma'am.
Okay, so you stay in contact with him. Has your number changed since January 16th?
No.
Okay, so I have that number. Has your address changed? Okay. Your bond was set at 10,000 personal recognizance with the no contact order in place for the protection of the alleged victim. That will continue. Any additional matters for today's record?
Your Honor, thank you.
I have a brief moment to consult with counsel, Your Honor, then I may have a brief matter to address with the court.
Yes.
Your Honor, if I may.
Yes.
Mr. Cox presented me with a letter. He has been offered a prospective job that would begin sometime in mid-March that would require, it is an out-of-state job. And what I would be asking if the court would consider modifying his bond to permit Mr. Hawks to live or travel out of state while the case is pending, only for the purposes of his employment.
Oh, see the
May
letter?
I approach? Your
Yes,
Honor?
please. And the people have reviewed this letter.
Yes, Your Honor, I looked at it. It appears to be a legitimate offer letter. We would leave it to the court's discretion.
Fine, have something you want to say?
I believe so, Your Honor. This is kind of a follow-up regarding his employment history. I have no problem with him addressing that issue with the court.
Okay.
Your Honor, this is the best job opportunity I've had in my life. I was working to build this around the same time that Emily and I met. I've been on a contract ship for the Department of Defense, traveling to various states over the past few years. Basis, remember, this is for the Air Force. Start date is supposed to be March 11th. I would love to continue my career in our country. That's all I have to say.
Thank you. I'll grant the request and allow to travel for the purposes of his employment. Here's your exhibits. Here's your request. Any additional matters for the record?
Nothing additional, but Mr. Hawks, Your Honor. Thank you.
Thank you. You're all set.
Thank you, Your Honor.
Ms. Donnelly, you have Mr. Reed here?
I do. And also Ray with Mr. Brown.
We're running Mr. Reed.
Yes.
How many witnesses do you have on Reed?
Double check, just the one, I believe, Your Honor. Just single witness.
Okay, on the record in the matter of the people of the state of Michigan versus Jamel Eric Reed, file number 24-00123, counsel with parents.
Prosecutor, please, Petrosky, on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Jamel Reed, who is present and standing to my right.
Okay, how are you, Mr. Reed?
All right, Your Honor.
The date and the time that was set for a preliminary examination on a police officer fleeing fourth degree. My understanding is we're ready to call witnesses. Any preliminary matters?
Nothing from the people.
Nothing for defense.
As fourth degree habitual offender, second offense needs to be clear. Okay, you can call your witness.
Thank you, Your Honor. The people call Trooper Calvin Harshman.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat, officer. I'm sorry, Trooper.
Right.
And please state your first and last name and spell both.
Yes, first name is Calvin, Calvin. Last name is Harshman, Harshman.
Proceed, counsel.
Thank you, Your Honor. Good afternoon. This is Trooper Harshman. Were you, or where are you employed?
Michigan State Police, Lansing folks,
How long have you been employed there?
6 years.
Were you working on January 16th, 2024?
Yes.
And what were you doing on that day?
So I work in the city of Lansing on the Secured City Squad, in conjunction with LPD's Violent Crime Initiative Team, doing patrol with them.
Did you initiate a traffic stop on that day?
Yes, ma'am.
And are you able to describe the vehicle that you stopped?
Yes, red Chevy Malibu.
And why did you initiate that stop?
The VCI officers noticed, read out the plate for the suspect vehicle, and it showed EIV no, which is no insurance. Last time Secretary of State checked, and when they were behind the vehicle, they saw that it did not come to a complete stop at a stop sign.
Did you personally witness that?
Not the stop sign, no.
Not the stop sign, but you.
I ran the lean check on the vehicle.
I'm sorry, how did you know that it didn't come to a complete stop?
LPD officers witnessed that.
Oh, okay.
And so when you initiated the stop, how did you do that?
Yes, so I got onto Willow Road and the vehicle pulled into the gas station. I stopped, I got behind the vehicle in the gas station, activated my overhead lights and activated my sirens.
And were you in a marked police vehicle?
Yes.
Were you wearing a police uniform?
Yes, ma'am.
So what happened after you activated your lights and sirens?
Activated my lights and sirens, the car began to, it was at a stop, it started moving and pulled out of the parking lot.
And what happened after it pulled out of the parking lot?
After it pulled out of the parking lot, I turned off my lights and sirens and alerted dispatch that I attempted to stop the vehicle and it took off from me. After I alerted that, the car drove approximately a block, lost control and came to a stop on a corner.
And then at that time, did you make contact with the people in the vehicle?
Yes, ma'am. I parked my patrol car behind the vehicle. The front seat passenger fled on foot. I alerted other officers in the area of that, and I made contact with the driver.
And who did the driver provide his name?
Yes, ma'am.
And what was his name?
Jermaine Reed.
And were you able to see his face?
Yes, ma'am.
Would you recognize him if you saw him today?
Yes, ma'am.
Is he present in the courtroom?
Yes, ma'am.
Can you describe where he's located in our clothes clothing?
To my left, to your right, wearing a gray jacket and orange hoodie.
Let the record reflect that Trooper Harshman has identified the defendant.
Any objection to identification?
No, Your Honor.
Identification is noted.
Thank you, Your Honor. Did the defendant say anything to you when you met with him when the vehicle stopped?
Yes, ma'am. I gave him orders, put his hands up and had him exit the vehicle, and he was questioning why I was stopping him and what was going on.
And just to clarify, he was in the driver's seat?
Yes, ma'am.
Okay, just to clarify. And so you said you were on Willow Street?
Yes, ma'am.
And that was when you had initiated the traffic stop?
Yes, ma'am.
Is Willow Street located in Lansing, Michigan?
Yes, ma'am.
Hingham County?
Yes, ma'am.
State of Michigan?
Yes,
No further questions.
Good afternoon, Trooper
Good afternoon.
Hartman. All right, so your testimony is today that you did not witness the red Chevy Malibu failure to come to a complete stop at Willow and MLK.
Yes, ma'am.
All right, and you said that another law enforcement officer had witnessed it.
Yes, ma'am.
All right, and but you said your testimony here today is that you said you ran the plate?
Yes, ma'am.
All right, and so you discovered that this vehicle, this red Chevy Malibu, was not insured.
Yes, ma'am.
All right. And then hold on, just. And was it your testimony that you did use lights and sirens when trying to pull him over?
Yes, ma'am.
All right, did you do you remember, or do you recall when you initiated the lights?
When I pulled into the gas station.
Okay, and did you leave the lights on?
I turned them off after the car left the gas station.
Okay, so when the car leaves the gas station and proceeds, I think, turning left, you turned your lights off at that moment?
Yes, ma'am.
Okay, and then your sirens, did you have those on all the time?
No.
Or how often, when did you use your sirens?
I turned my lights on and didn't hit my sirens. They were never like steadily on, just held our horn, activated the sirens, held that down, and then once I let go, the sirens turned off.
Okay, and so when you were traveling behind him down, was it Kaywood?
Yes.
You didn't have lights or sirens on?
That is correct.
Okay. And of course, so when did you run his plate and find that the car didn't have insurance?
When the other officers, the undercover officers, saw the vehicle, they provided the plate and I ran it then.
Okay, all right. So you knew before he failed to come to a complete stop that he didn't have insurance, or the car didn't have insurance?
Yes, ma'am.
All right, so and then did you try to pull him over before the gas station, or were you not able to?
No, there was other vehicles between our vehicle, and once you pulled into the gas station, other vehicles kept going, and I pulled behind him at the gas station.
All right. And was that other vehicle did you recognize that vehicle between you and the Malibu?
The one directly between us, yes.
Yes, was that it was an unmarked vehicle that was being driven by a law enforcement officer in their duties?
Yes, ma'am.
Okay. Your Honor, no further questions.
Can you read your right?
Yes, so can you give an estimate of how long your lights and sirens were on for?
Our lights were probably on, if I had to guess, 10 seconds, and sirens.
And was when you initiated the stop, when you turned on your lights and sirens, do you know how fast the defendant's vehicle was moving?
When I activated, the vehicle was not moving when I activated my lights.
Okay, and then after you activated your lights, what happened?
The car accelerated and drove off the parking lot.
Okay, no further questions.
May this trooper be excused?
Yes, he may, Your Honor.
Thank you, Trooper Hartman. Any additional witnesses?
No, Your Honor.
Any witnesses from the defense?
No, Your Honor.
Okay, argument?
Thank you, Your Honor. I would just state that Officer Harshman's testimony established all of the elements, established venue on Willow Street in Lansing, Ingham County, This took place on January 16th, 2024. He was in a clearly marked vehicle, initiated a traffic stop because defendant's vehicle did not have proper registration. Utilizing his lights and sirens, he attempted to initiate a traffic stop. The defendant's vehicle was not moving. After initiating the traffic stop, that was when defendant's vehicle accelerated and left the parking lot, thus satisfying the elements for fleeing and eluding. Thank you.
Thank you, Your Honor. Yes, we are here for probable cause. That is a low burden of more than mere suspicion, but it is a burden that the prosecution carries. So in regards to the elements, they have to show by more than mere suspicion that Mr. Reed was given a visual audio signal by hand, voice, emergency light, or siren. Trooper Harshman's testimony today was that he briefly used lights and siren, but he did not have his siren on completely, and of course he turned his lights off after Mr. Reed left the parking lot. He also testified that he was in his marked vehicle, he was in full uniform, he was working with and surveilling with the violent crimes group here in Lansing. I don't believe there was any testimony presented. Well, he testified that he believed that Mr. Reed was speeding away, but there was no testimony any other evidence that showed that Mr. Reed willfully failed to obey that officer and was attempting to flee. So thank you, Your Honor.
Thank you. Today was the date that was set for the preliminary examination. As your attorney indicated, the burden is on the prosecutor. They have to establish sufficient probable cause that a crime was committed and then sufficient probable cause to charge you with that crime. And since this is not a trial, they don't have to prove each element beyond a reasonable doubt here. They just need to show that they have more than mere suspicion that the crime alleged was committed. It's a common sense burden. It's pretty flexible, and it's based on the testimony and facts presented today, I'll be the sole determiner, that is, of credibility of the witness. We had witness here, Trooper Harshman from Michigan State Police, indicating that on or about January 16, 2024, that he was in the area of Willow at or near Kaywood, and that he was behind a vehicle, which he indicates he received information about prior to, but that he ran the plates, he understood the vehicle to not have valid insurance, indicated saying he ran the vehicle, it came back EIV no, meaning there was no valid insurance the last time the Secretary of State checked, that the trooper then attempted to effectuate a traffic stop by activating his lights and sirens. He testified that the vehicle started moving after those lights being activated. Again, the trooper indicating he was in a fully marked Michigan State Police vehicle, that the vehicle accelerated and pulled out of the parking lot, and at some point lost control, hit the curb, passenger fled on foot, and that the officer then was able to make contact with the driver of that vehicle, the driver he identified in the courtroom today as being Mr. Jamel Reed, and that the driver questioned the officer as to why he was being stopped. The count one of police officer fleeing or eluding fourth degree under the vehicle code will require the prosecutor at the time of trial to prove first that the police or a conservation that is officer was in uniform and was performing his lawful duties, and that any vehicle driven by the officer was identified as a law enforcement vehicle. Second, that the defendant was driving a motor vehicle. Third, that the officer ordered that defendant to stop his vehicle. Fourth, that the defendant knew of the order. And then fifth, that the defendant refused to obey the order by trying to flee or avoid being caught. The officer again indicating in his testimony that he was in fully marked uniform and he also was in a fully marked police cruiser, that being by the Michigan State Police, that he was performing his duties under the Secure Cities Initiative, patrolling the area and responding to, I guess, a call or dispatch that he received from an undercover non-marked officer from the Lansing Police Department. And then that the defendant was driving a motor vehicle. The officer or the trooper testified that he did activate his lights. He testified that they're not a continuous active light, but that they were activated, and it was based on his perception that there was enough indication that he was activating his lights to cause this defendant to pull over. Whether or not this defendant knew that he was, the order was for him, it's a question of fact at this point, but the court will take into consideration that the lights were activated, the officer being in a position that was behind the defendant who was operating the motor vehicle. Allegedly, defendant continued to accelerate until the vehicle lost control, hit a curb, and then someone in the car with the defendant flees the vehicle. That would cause the court to believe that the defendant knew that the car was being pulled over, and whoever was in the car with them didn't want to interact with the police officer, so that's why they were slow to stop, and that's why they fled. And then the first, or the questions that the officer or trooper indicated that the defendant questioned about was, where am I being stopped? The court is satisfied that there's sufficient probable cause as to count one police officer fleeing 4th degree under the vehicle code. That will be bound over to the circuit court. Your bind over date is going to be February 14th. That's the date the circuit court gets the file from the district court. That is not the date you need to appear in court next, okay?
I'm sorry, say that again. You're speaking about something.
No problem, no problem. That bind over date on this file is gonna be February 14th. When I say bind over, that means we're sending this file to the circuit court on that date. So you don't have to appear in court on that date, okay?
I don't have to appear on the 14th.
Not on the 14th, not at all.
They get binded over.
That's the date that they're gonna get the file from this. After they receive the file, they will set it for a pre-trial. Ms. Donnelly will be made aware of that date, okay? She'll be in contact with you. Has your number changed since January 17th?
No.
Has your address changed?
No, ma'am.
Okay, and so should any of those things change, it's your responsibility to make sure your attorney and the court is notified, okay?
Yes.
Okay, your bond was set at 1,510%. That will continue. Any additional matters for today's record?
Nothing for the people, Your Honor.
Thanks.
You're all set, sir.
Okay.
Well, no, because we have a right to have a lunch break.
Okay with that.